Chris Bebel here again. I'm a former federal prosecutor and I'm a former SEC attorney. I'm now in private practice and I represent investors who have been defrauded. Indeed, I've represented investors in cases docketed from coast to coast, and I've given presentations about the pursuit of securities fraud cases to numerous groups of lawyers, and I'm a published author in the securities fraud area. So what are we going to talk about today? Well, today we're going to talk about an argument brokerage firms frequently make in connection with an effort to escape liability. Now, let's look at things in their proper context. I recently gave a presentation wherein I discussed the rapid growth of independent broker-dealers. Now, what's common in this sector is that the underlying stockbroker will be located in a so-called remote office, and that can be located 1,000 miles away or more from the supervisor that is charged with the task of supervising that broker's activities on an intense, detailed basis. Now, as I previously stated, the challenges of conducting proper supervision in this type of setting can be very difficult. They can be immense. For instance, let's bring this to life. If the supervisor is over 1,000 miles away, how is that supervisor going to be certain that he is really and truly analyzing and reviewing all of the incoming and outgoing correspondence that is received via the U.S. mail at that remote office? Common sense tells us that the stockbroker is equipped with the right to simply forward the items for review that the broker wishes to be reviewed and hide the remaining items. And that is totally inconsistent with fundamental notions of adequate supervision. So let's continue on, proceed with this analysis. As I was saying, in the independent broker-dealer context, brokerage firms often try to escape liability by claiming that the stockbroker in question is an independent contractor, and thus the brokerage firm cannot be held liable. Well, in a nutshell, succinctly put, that argument carries no weight. It is completely devoid of merit. As the SEC noted over 20 years ago, it really makes no difference whether or not a stockbroker is classified as an independent contractor or a conventional employee when allegations are brought under the Exchange Act. And indeed, that's generally where allegations will be brought. The allegations will rest on the Exchange Act when federal securities law violations are alleged. Now, let's extend the analysis further. Let's go on to the next step. Let's look at FINRA, the Financial Industry Regulatory Authority. What does it say on this subject? Well, FINRA is of like mind. FINRA has likewise made it clear that there is no merit to this argument. And that makes sense. That makes sense. Why is that? That's because it would make scant sense for regulators to devise a complex system of rules and regulations so as to make sure that investors are protected and so as to make sure that the supervisory obligations shouldered by brokerage firms are in fact carried out if the brokerage firms could easily do an end run around those rules simply by labeling a given broker as an independent contractor. That would effectively eviscerate the supervisory requirements that serve as a cornerstone principle of broker-dealer law. So, bottom line, if you're an investor and you're involved in a lawsuit or an arbitration case wherein the brokerage firm has asserted that it cannot be held liable because of the fact that the stockbroker in question is an independent contractor, you need not lose any sleep. Don't be worried about that. That argument is not going to get any traction. But keep in mind that if you're being represented by a novice attorney, by an attorney who is not schooled in the securities litigation, securities arbitration area, that attorney may mistakenly attach some weight to this type of argument. And as a result, he or she may pressure you to settle your case for less than it's worth. So, in a nutshell, the lesson learned is that it's important to be represented by an attorney who is seasoned, who is experienced in the securities arbitration area, the securities litigation area, and is familiar with broker-dealer rules and regulations. Stay tuned. We'll soon have another video ready for you wherein we will discuss in more detail other areas of securities law that are important from an investor protection standpoint. Thank you.